Allister.
Thank you, Deputy Speaker. I wish to begin by refuting the suggestion that to oppose this bill is to endorse harassment, abuse or violence. It is none of those things, and I absolutely throw back that slur which has been cast at those of us who would dare to question the need for and the content of this bill. And in that same vein, we have had much diversionary, emotive presentation in support of this bill, even to the point of calling an aid a distortion of Baby Loss Week. We're talking about abortion. We're talking about the ending of babies' lives. But yet, there are those who in this chamber have sought to call an aid Baby Loss Week, which is about those who lost babies not through choice. Yes?
I appreciate the member for giving way, but will the member acknowledge that some of the images that are shared often at these protests might actually compound that trauma of Baby Loss Awareness Week? I've been contacted by constituents who have suffered miscarriage and are not happy about these images. Would the member acknowledge that?
Could I remind members to make sure that their microphone is in front of them and they're speaking into it so that everything will be recorded?
Those persons would not be protected by this bill. This bill's definition of protected person is those going into these facilities or accompanying those going into these facilities. So the point the member raises is a non-point in the context of this bill. I'm being surrounded by requests, but certainly start with the lady, if that's not offensive.
I thank the member for giving way. I would ask the member to consider what he has just said, to think if he understands for 1 second the circumstances of any woman who finds herself in the position of needing a termination, and also ask him to consider whether or not it is appropriate to comment as he has just done.
I consider all those things, and I consider it is. Mr.
Thank you for giving way. Would he not consider for one moment that some of the women going in to these premises either seeking a termination or seeking advice on a termination are in some cases people who themselves have suffered miscarriage before, and part of the reason why they may be going in to seek that advice is because there are medical complications, personal reasons. So these aren't different categories necessarily in the way he draws, and it's deeply and profoundly offensive to many women and many families who suffer baby loss and sometimes have to make these very difficult choices later on.
The lady is going in to seek advice about complications in her pregnancy. She'll be going to her GP or a hospital. Don't think she'll be going to an abortion clinic. Well, I think I do need to make some progress. I'm generally generous with my allowing interventions, but I do want to start. I haven't even started my comments to any extent on this bill. So I'm not distracted from the fact that this bill, like any bill, therefore does require rigorous scrutiny as to what it really is seeking to do. And you don't have to read very far into this bill to detect the direction of travel. Clause 1(2). Acts within a safe access zone which may have the effect of preventing or impeding the access to the premises or influence, harassing, alarming or distressing persons assessing the premises are criminalised. Let me read that again, but focusing on one word. Acts within the safe access zone which may influence persons accessing the premises are criminalised. Think about that. That this House has been invited to legislate that something that may, doesn't have to, may influence another should be criminalised. Think of the mother, the distressed mother, of the 14-year-old daughter who finds herself pregnant, who's going to a clinic to get an abortion. The distressed mother is begging her not to go through with the abortion. This law says the mother's the criminal. That is not where the state should be going in regard to this matter. If there's any doubt about that, turn to clause 6. It is, in this section, 6.2, it is an offence for D, that's the person who's not a protected person, the defendant, D the defendant, to do an act in a safe access zone with the intent of or reckless as to whether it has the effect of influencing in connection with the protected person attending the protected premises. So yes, the mother, the distressed mother of the 14-year-old who's pregnant, who's going for the abortion, is criminalised because she has the intent to want to influence her not to do it. How can that be right? And yet that is what this law does. And of course, let us not forget, the protected person can be a minor as well as an adult. This law is directed at that 14-year-old girl as much as it is at the 24-year-old woman. And yet we are picking upon the mothers, maybe distressed by that situation, who want to bring motherly influence to their daughter, who follow them down to the clinic, pleading with them not to have the abortion, and they become the criminal. There's nothing upright, proper, legitimate about that approach. I'll give way.
Thanks to the member for giving way. I again want to refer back to his earlier comments because you've just outlined a particular situation or circumstance, but I would again ask you, you took umbrage at the fact that members had made reference to the fact that this is Baby Loss Awareness Week. I would ask you again, can you say categorically that you understand the circumstances of every woman in the north of Ireland who seeks terminations? Because I don't think that you can, and therefore how dare you criticise those women or suggest that those women haven't experienced a loss, or some of them haven't experienced a loss.
I have been listening. I was criticising those members of the Northern Ireland Legislative Assembly who abuse the very principle and ethos of Baby Loss Week in aid of the destruction of babies. That's what I was criticising. But think of another situation. That's what this bill actually means. Let's say someone, through their own religious, conscientious conviction against abortion, and the direction of travel in this bill is it will soon be criminalised to have any view contrary to abortion. But let's take someone who has a religious, conscientious conviction about abortion, and they decide the abortion clinic is somewhere they're going to go, not to shout, not to lobby, not to block people, but they're going to go and hold up a poster. And that poster might simply have the immortal words of the 6th commandment: "Thou shalt not kill." And because that, in the terms of this bill, is capable of influencing someone, causing them, as the protester intends, to stop and to think, do I want to kill the baby in my womb? Because it has the capacity to cause them to be influenced by that. That protester doing nothing but holding those few words is a criminal. That is a preposterous proposal. And yet, it gives us an insight into this bill. This bill is vindictive against freedom of expression. Freedom of expression is not just the right to express the palatable. Freedom of expression equally is the right to express the unpalatable. And yet, the person who reminds the users of the facilities of what, in their view, is a cardinal and sacred position, that thou shalt not kill, is the person who in this is criminalised.
Thank the member for giving way. It exasperates me, the lack of self-awareness that the member has when I listen to his contribution so far. But I would ask the member to, does he agree that harassment can be interpreted in many different ways? And for someone who's made that very, very difficult decision, something that they've probably deliberated for weeks and days and nights and haven't slept, and had to go in and make that very, very difficult decision, that poster that you talk about may be interpreted as harassment because it's infringing on their right to make a decision about their own body and to come to a conclusion which isn't easy for any woman and something that you probably can't have an understanding of. Would the member agree with me?
No, I would. If the content of Holy Scripture is harassment, then maybe it bears out the point that Holy Scripture should be a conscience pricker in many avenues of life. Yes, I'll give way.
Mr. Allister, for giving way. I suppose it's really just to extend Ms McKimmon's point around harassment, and the member will be aware that current harassment law very much focuses on the person being harassed rather than the person who maybe thinks or doesn't think that they're doing the harassment. So what would the member say in relation to that? Should these people protesting have a self-awareness around the potential of them harassing, particularly if it's a repeated offence?
Let's deal with harassment. You draw me to a point, actually, that intrigues me about this bill. In clause 1.2 that I read, it talks about influencing, harassing, alarming, or distressing. And again, clause 6.2, causing harassment, alarm, or distress. Now, harassment is defined, but not in this bill. And harassment is defined in the Protection from Harassment Order. And what is harassment? It's causing alarm or distress. So what does this bill mean when it says harassment, alarm, or distress? Is it just being tautologous? What does it mean when it says harassment? Since the very word harassment in our criminal law is already defined as alarm or distress. And yet, additionally, we have some ill-defined, undefined harassment in this bill. And when you go to the interpretation section, harassment isn't defined. So, I'm no doubt the sponsor in Winding will tell us what harassment is if it isn't causing alarm and isn't causing distress. Because that's the only definition of harassment there is in our law. If we're bringing in a new definition, then it needs to be spelled out. What is it? And I think the House is entitled to ask and to know the answer to that question. Yes?
I appreciate the member for giving way again. But again, will the member acknowledge that under the current definition of harassment, the focus is on what the victim feels around that harassment? The point he's trying to make is about the protester, but if we were putting this into the context of a potential harassment offence, does the member recognise that that harassment is about the victim? You've talked about distress of the victim. Does the member acknowledge that this isn't about what's necessarily defined in this bill, this is about what's currently defined in law? Does the member recognise that whilst he's trying to make a point around what the protester might do, that their actions may actually be an offence?
That It's quite clear to me what the law means when it says cause alarm or distress. It means cause alarm or distress to a third party. Of course it is. So that's not the issue here. But the issue is, on that particular, that we have now this undefined perception of harassment, which clearly isn't alarm or distress, or the bill wouldn't have been drafted in that tautologous way. If it simply means alarm or distress, then you don't need the word harassment. So clearly it means more than alarm or distress, hence the use of the word harassment. What is that meaning? I don't know, because we're not told in this bill. Could I just draw attention to one or two other things in this bill? Clause 9 is about the exercise of functions, and this relates to the Department of Health. The Department must have regard to, amongst other things, safety and dignity of protected persons, the right to respect for private and family life, the right to manifest religious belief, and the rights to freedom of assembly and expression set out in Articles 9, 10 and 11 of the Convention, and in particular, the right to protest. So we're told in Clause 9 that the Department, and this is about making their zones, etc., their censorship zones, that they must have regard to the right to protest. But go back to Clause 8.2. Within 8 weeks of receiving this notification, the Department must designate an area as a safe access zone. So there is no scope to be influenced by the right to protest, about the manifestation of religious belief. It is expunged by 8.2. It is only there as for presentational purposes in Clause 9. And if ever there was any doubt about that, paragraph 5 of the explanatory and financial memorandum couldn't be clearer. This bill does not include provision for protesters. There it is, in black and white. This bill is about expunging protest, about oppressing protest. This bill, for all the fancy words of Clause 9 about having regard to protest, is in the business of the very opposite. Yes, okay,
Mark. And on that point, would he agree with me that the very vague and open nature of this bill, which he has quite articulately pointed out in relation to the contradictory nature when we go to 9C and that right to manifest in religious belief, the freedoms of assembly and expression set out in Articles 9, 10 and 11 of the Convention is merely what seems to be an afterthought if we look at the functions and provisions provided in Clause 6?
It's quite clear that it's there to try and paper over the fact that this bill is an all-out assault on freedom of expression, an all-out assault on the right to protest. And, you know, the proof is in 8.2. The Department must make the order. Never mind what it has to have regard to notionally. It must make the order. So this bill is fraudulent in that respect, in pretending that, in fact, the functions are exercised subject to Clause 9, and when they're overridden by the compulsion of Clause 8.2. That's the reality. On this point, well, are we in a situation where we have no law to deal with this? Well, we're not. I've already made that point in interventions. Harassment, and yes, points can be made that there has to be a course of conduct, which is defined in the 97 order as more than one occasion. Well, there's a very simple answer to that. Remove the course of conduct requirement in the harassment order. If that's the problem, that's the solution. But not a bill which carries you way, way into the realms of making it unlawful to try to influence someone. That's the real nub of the objection to this bill. So we do have harassment laws. You can get a harassment injunction You can have a restraining order under the harassment order, which is for future attention, to put someone under a curb in terms of how they can act in future. So those things, amongst many more, already exist. Yes, I'll give way.
I thank the member for giving way, and he has been very generous with his time, but does his exact point about harassment law, recognising that this needs to be a course of behaviour, as in more than one occasion, and also outlining the restraining order requirements, not point to the need for this bill? That you cannot have a restraining order on one instance of harassing behaviour. It's for future behaviour, and in the instances that we're talking about, generally speaking, these women are not going back to the clinic.
We've had justice bills, justice amendment bills before this House. Why did none of the members, if they're exercised about this issue, not move an amendment to the harassment order to remove the code of conduct? That was the simple answer. Then it was something which had universal application, not just in respect of these protected premises. That was a far easier route to follow, and one far less objectionable. And of course, I also remind you, there are powers under the Public Order of 87, Article 5, whereby the police, in the proper circumstances, can forbid public gatherings at locations. The law, why are we reinventing the wheel on this in that regard? It is already a breach of the law to engage in offensive, malicious communications under the Communications Act, never mind the public order definitions, which also cover those manifestations. So we have the protection from harassment order, we have the disorderly behaviour and public order offences in the public order, and all of that, Article 9 of the public order makes it an offence to use written material which is using threatening, insulting or abusive words. It's already there. It's in Article 9. So I do again say, and in fact, for that you can get a heavier sentence. You can get 6 months jail as opposed to what's in this bill. So why are we reinventing the wheel in this bill on those issues? And I do remind the House that other responsible legislatures and governments that have looked at this issue have come to a very different conclusion than this private member's bill. The Home Office examined this issue in great detail, decided in 2018, I think it was, that this was not the way to go. Scotland, often held up by some in this House as a great example of how to do devolution, decided not to have these protection zones. And I do think that we are setting a dangerous precedent trying to impinge other people's opinion. We really want to establish censorship zones where only the sponsor's approved set of values can be articulated. That is not the sort of society we need, that you're so oppressive of others' opinions that you create zones where only the approved set of values can be expressed. Yeah.
I thank the member for giving way on this point, and would he care to make reference to and elaborate on the fact that many in this House have articulated that this would just be in a health trust setting, but actually the wording of the bill actually makes it much more vague, meaning that this could, in effect, given its openness and vague nature, could and perhaps actually spill out into other areas across our towns and villages in Northern Ireland.
And one of the reasons for that is there is no limitation on the potential extent of the censorship zone, none whatsoever. It could embrace a whole town if that's relevant. So, this is a bill, an open invitation to this House to create censorship zones because people want to express within those zones values and views which offend the sponsor of this bill. They wish to decree that views which are disagreeable to those like the sponsor are so wrong, that they must be forcibly driven from the public square. Now, that really is the essence of these censorship or exclusion zones, that views are so disagreeable that they cannot be heard. They cannot even be on a poster, lest they did have the effect of influencing someone. That, to me, is a flagrant attack on liberty and on freedom of expression. As I said before, freedom of expression equally embraces the expression of the unpalatable as well as the palatable. Otherwise, freedom of expression is meaningless. And the logic and the purport of this bill is to suppress freedom of expression, to drive it from the public place, from the public forum, on the basis that it is disagreeable to the views of others. That's totalitarianism. That's not liberty, such as many in this House from time to time proclaim a belief in. So I do say to this House, this is not a bill that I can support, because it is a bill which goes far too far, which is far too oppressive of rights of freedom of expression and rights of protest, all in the interest of excluding anything but the pro-abortion view.